Good afternoon, everybody. We are all well. My name is Michelle Chu. I'm the post-political paralegal here in Thomasville, and today I'll be presenting on this topic: what can a beneficiary do if an executor of a will fails to live up to his duties? So for this webinar, we'll be touching on three areas. So number one is the general duties of an executor. I won't go this in detail as I will cover this quite a bit in my previous webinar on this in September. And next, we'll be talking about the examples of breaches which an executor may commit during the course of execution of the estate, and as well the main point, the main gist of this webinar: what are the legal costs of actions available for the beneficiaries if they are unhappy with what is going on with the administration. So shall we move on? Okay, who is an executor? So you may hear this or maybe saw this word somewhere in a will or in any papers. It actually means in the case where somebody passed away, leaving a will, the executor name in the will will be the person to execute the will. So in a sense, like that person, the executor, will be the one to administer the estates one, once you pass away. So in here, I will use this terminology which is called the testator, meaning the will maker. And so the executor, in short, you can see here, is a person appointed by the maker of the will maker, or what we call as testator, to be responsible to manage and distribute the assets to the beneficiaries. And it's very important for you, if you're going to prepare a will for your own, to appoint somebody who is reliable, adequately skilled, and very importantly, very trustworthy one to be your executor for your estate once you pass away. Because once you passed away, you can't control what's going on after that. Am I right? So in order to ensure the effectiveness and efficiency of the administration and distribution of the estate, and also to just keep the how to say that's one less thing to worry about, because once you passed away, it's very hard on the family itself. If you appoint somebody whom all parties trust, and also adequately skills in terms of how to manage finances, how to deal with the ins and outs of the estate, it will definitely ease the burden of the beneficiaries and also the person around, surrounding the estate. So as mentioned just now, I've covered the duties of an executor in detail in my previous talk. So I won't go into the all of the details on that. For this talk, we will look at the duties in general only. So executor, you are expected to do a couple things. You have to find the original copy of the will. You have to apply for the death certificate. You have to engage a lawyer to assist you to apply for a grant of probate. The grant of probate in court is technically like the letter to give you authority to administer the estate. Of course, if you are already appointed under the will as an executor, you can actually carry out the administrative duty itself without the grant of probate, of course. But however, it's best to have the grant of probate, a sealed grant of probate by the High Court of Malaya, to acknowledge that you're the executor, to be validly appointed executor, to avoid further confusion or any miscommunication in respect of that, in respect of the authority. And also, you have to call in all the assets of the wills maker assets when they pass. So by doing this, you just have to look at the will on what are the assets listed in the will. Of course, this is your first step in doing so, but there is a possibility that a will maker may not be able to put in all the assets that they have. They might forget some small shares or title, or maybe they are unaware that they are entitled to some interest involved in a company, or maybe some sort of land. So it's best to call in all the assets by maybe do investigative research, or maybe something pop up at the end. You never know. And also, before you distribute the assets as per the will, you have to pay all the debts and liabilities. So it's very important for you to ascertain all the debts and liabilities and pay off those liabilities before the distribution of the assets. And after all these, maybe you can do this in the interim as well. You have to prepare an administration account in respect of the ins and outs of the estate. So what have you paid for? What are the assets which you are liquidated, part of the estate as such? It's important to take note of this because it's actually statutory required under the powers of the Probate Administration Act for you to prepare accounts, a perfect inventory and account. It does not have to be a complex one. You don't have to appoint an accountant for that. As long as it's clear and simple account ledger is fine. As long as it's clear to show that what have you done, what 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 were the money spent for the estate, what can you account for, and whether those expenses can be justified. So, and of course, all executors are expected to carry his or her duties with reasonable honesty, diligence, and prudence. Why? Because executors owes the beneficiaries a fiduciary duty. So we are expected to carry out the duties diligently. You may be expected to reinvest some of the properties if required, or if necessary, you may have to repair some of the properties in order to resell, in order to increase the value for the benefit of the estate. So it depends on the estate that you are managing as an executor. Although you don't have to be a financial expert or expert in evaluating the values of the estate, you are not legally required to be that skilled, because you can employ or appoint an expert to do those for you. What you can do is just to administer the estate, uh, monitor what's been going on. You just monitor whatever it is and do the necessary accounts. So it's important that because of the duty involved, you have to do your job properly. If not, you may be in breach of your duties. So we have covered in general what are the duties of an executor. Now let's see what are the examples of features of fiduciary duties. So, for example, engage in self-dealing, spending the estate monies for your own benefit, like in your pocket, or you did not preserve the estate's assets for payments of debt. Right? For example, like what I said just now, once you got all the assets, you straight away distribute it without paying off the debts. This is a big no-no. And you did not maintain the properties. Like, for example, payment of debts can last for years. If for example, if you intend to keep one, for example, the house for distribution purposes, if you did not maintain the property in the course of 10 years, the property uh, definitely will deteriorate. It will there might be repairs involved. So if you don't maintain the property, the value of the property will drop because due to uh, the repair. You might have to repair the wall because of deterioration and whatnot. So or you make uncalled investments which cause losses towards the estate. In these examples, you an executor may be held for the monies involved, which we'll see in a few cases later. And also, on the other hand, you may also be held to commit breach of trust, because in essence, executors are trustees. So a personal representative, or meaning the executor herein, in accepting the office, accepts the duties of office and becomes the trustee, in the sense that he is personally liable and for all the breaches of trust. So let's see this section. Section 28, sub 3, sub A of the Trustee Act. An executor is guilty of negligence if he delays in taking proceedings or permits money, valuable consideration, or property to remain in the hands of the banker and solicitor for a period longer than is reasonably necessary to pay or transfer to him. So this section shows that you, an executor, you cannot sleep on your duty. You have to be diligent and exercise your due diligence to make sure all the assets have been called for in order to administer the assets properly. Let's see this case, Khan versus UT Zabadia. So in this case, the testator, or we know known as the will maker, owns a rubber plantation. So instead of making the regular sales that the rubber plantation used to make, the executor accumulated large quantities for months at a time when the price of rubber was continually falling. You might think that it's a plus like a prudent business choice, but it was held in this case that it amounts to willful default as well as a breach of trust, as he is liable to account to the beneficiaries for the loss which they have suffered. And also in this case, we can see that for this case, the executors are also the beneficiaries. So we can see from here is that it is not an excuse for you as an executor to sleep on your duties. In here, you can see that the beneficiary made complaints that the executor has not ascertained the assets, has not called in the assets, did not account to the beneficiary on what's going on, were not ready to give full and complete information of the estate in respect of the in and outs, have not distributed the estate, although they have accepted office 19 years ago. So in here, like I said just now, despite that the executors were beneficiary at that point in time, is not an excuse for you to sleep on your duty. And they shall not obtain an interim distribution of the trust fund, which is the asset at that point in time, until the final disposal of the serious claims made against the executor. So in this case, it can show that an executor generally shall not act to the detriment of the trust or convert monies belong to the estate for his own use. Okay, so when the testator's assets have come into the possession of the executor and afterwards lost their estate, the equitable rule is that the executor stands in the position of a gratuitous bailee. In the sense that if the assets if there's losses incurred in respect of that, the executor will be charged for willful default. So gratuitous bailment is a type of bailment which the bailee receives no compensation. For example, borrowing a friend's car. So a gratuitous bailee is liable for the loss of the property only if the loss of the property for my example, the car is only would be liable for the loss of the or damages in respect of the car only if it's caused by the bailee's gross negligence in that sense. So logically speaking, it should apply in that sense. But if an executor actually appointed a external agent or solicitor or a banker or stockbroker in the course of the administration of the estate, the executor is not responsible for the default for the third parties negligence in that regard, provided that because those parties were employed by the executor in good faith. So this is as per section 35 of the Trustee Act. Okay, so now you know the general duties of the executor and the examples of the breaches involved. So you may be wondering, as what if you are the beneficiary of the estate and the executor appointed under the will is not doing a great job? What can you do for that in that regard? So there we will be touching on two courses of action which is available to you if you're the beneficiary. So number one is what we call the administration action in pursuant to Order 80 of the Rules of Court 2012. So this is an action for the administration under the direction of the court of the estate of the deceased person, or for the execution under direction of the court as a trust. So in the sense that this administration is an application to obtain directions from court, it's not intended to be confrontational, meaning that it's not personally against the executor, but of course, practically speaking, if we're talking about this, if you're seeking the court for further directions on the administration of the estate, means that something is going on with the administration by the executor. As it impliedly gives a sour taste in the mouth as well, but it's on the face of it, it's not intended to remove the private executor of probate granted, but it definitely leaves a bad taste in the mouth. And the primary purpose is just to resolve difficulties, resolve any miscommunication, any confusion, or just to make sure that the executor is doing the just to put the executor in place. So during the action, you can seek the High Court's direction on the determination of any questions in relation to the administration or the execution of the trust, the composition of any class of person or beneficial interest in the estate of such person or in any property subject to a trust, or the rights or interests of person claiming to be a creditor or to be entitled under the will, or on intestacy, or to be beneficiary entitled under the trust. So parties who may apply under Order 80 are not only limited to personal representatives and beneficiaries of the estate, as creditors of claims and other persons interested in the proceedings may also apply to the High Court for directions on questions in relation to the estate. So the court is empowered to make orders such as requiring the executor to furnish and verify accounts. If the, like for example, in one of our in our previous slides, when I said that it's very important for an executor to prepare to account for the ins and outs of the estate. If the executor does not do a great job in that, the beneficiaries or can apply under Order 80 to ask the court to say that, well, my executor is not doing a great job. I need to know what happened. So the court may be like, okay, will make an order to require the executor to produce an account, an inventory account for the estate. Or the court may require the payment into court of money held by the executor, or directing the executor to do or stop them from doing something, or approve any sale of the chase or any other transaction in respect of the estate, or direct any act to be done in the administration of the estate. So other than the administration action, okay, you know that you have this course of action, but my executor is really not the executor appointed under the will is not doing a great job, and you think that there is sufficient cost for you, and you want there is the executor appointed under the will is not doing a great job, and the relationship between you and the executor has deteriorated over time because of the way the executor has conducted his duty. What can you do about it? You can opt for administration of actions to ask the court to give orders to ask the executor to comply with his or her duties, or you can apply under Section 34 of the Probate Administration Act to remove the executor and also maybe to get a new personal representative to administer the estate. So in a situation when the beneficiary is of the view that the executor has committed severe misconduct in the administration of the estate, he can seek removal of the executor by applying to the High Court under Section 34. So the test is actually the word sufficient cause. So to invoke the High Court's jurisdiction under this Section 34 of the Probate Administration Act, you will have to establish that there is sufficient cause, because when you see the section, the word here is sufficient cause. So what do you mean by sufficient cause? And how to prove that? The onus is actually on the applicant. So if you're the beneficiary and you apply under this section, you will have the burden to prove the sufficient cost. So you may have to adduce sufficient evidence to raise a strong suspicion of the executor's inaction, want of diligence, or maybe dishonesty, or even that if there is conflict of interest. But ultimately, later we will see in a couple of cases that the welfare, or what I would like to say, interests of the beneficiaries are the most important consideration in such application. The court will actually prioritize this, and because the term sufficient clause is not defined in the Probate and Administration Act, um, hence the process in finding what is the sufficient cost will consist mostly on questions of facts. So, but ultimately, we will see in the cases later, the court will actually prioritize the interests of beneficiaries, because ultimately, if you prepare a will, the end goal is to uh, the end goal of a will is to actually make sure that the intended beneficiaries get a share of your assets. So if you can see here in this case, Liga Fernandez versus Eric Claude Cook, the applicant will have to adduce sufficient evidence to raise strong suspicion of the executor in action, one of diligence and dishonesty, or a conflict of interest situation or inability to act. But in a more interesting case, which is this case, Damayanti Kantila Doshi versus Jigala Kantila Doshi. In here, the executors, uh, this is a very good example of a red flag that you as a beneficiary should take note of if the executor have failed to take preliminary steps in the administration of the estate, failed to render accounts, failed to take appropriate steps to prevent dissipation of assets. Maybe they did not, the executor did not maintain the property and the value of the property deteriorate, or they failed to sell the shares in time, and before they could do that, the shares have already plummeted in value, or the relationship between the executor and the beneficiaries are not in really great terms. So, and also in here, even though I said before that if you're an executor appointed under the will, the law says that you have the authority to administer the estate, but however, it's best for you to apply for grant of probate as soon as possible, just to avoid any mishaps going on. So in here, the ground of probate is not extracted after the lapse of 7 years. So here, the Court of Appeal held that there was enough material to support the allegations leveled against the executor that they had not properly discharged their duties. So the beneficiaries have shown sufficient cause pursuant to Section 34. And in this case, the court prioritize the interest and welfare of the beneficiary, because ultimately, if you have a will, the main goal is as such. In this case, Mak Chi Chong versus Rock Will's trustee Berhad, the fact that the relationship between the beneficiary and the executor has deteriorated to extent that the executor can no longer effectively administer the estate constitutes sufficient cause. I will understand the reasoning behind this because, for example, in a situation where if I as an executor, I have a piece of land and to administer, and in the interest of the estate, I may have to sell off the land. In order to do so, I have to tell the beneficiaries of what I'm going to do in order to obtain their consent and also to apply to the court for an order for sale. If I don't have if I can't even communicate with the beneficiaries, or the beneficiaries does not want to even meet up to actually discuss about this sale, this relationship cannot go on. So for a win-win situation as a beneficiary, you can actually apply to remove the executor if you don't intend to liaise with this executor in long term, or as an executor, of course, it's off topic. as an executor, if you're not willing to take on the responsibility, or it is it, it is no longer a prudent, it is no longer a it is no longer a good for you to continue on in taking up the duty, because this is a heavy this this sorry this position as an executor carries heavy responsibility. So if you sleep on your duties or obligation, it will cost you legally, in terms even in terms of money. So if you can't move on, it's best for you to renounce as an executor, or maybe just resign as an executor. In other situations, examples, which the High Court has revoked the grant of probate, meaning remove the executor. So if there's serious misconduct in general, or where the executor is not suitable for the position, or where the grant of probate was obtained by misrepresentation and fraud. So in short, when you if you see the previous cases that we see, we can learn from the cases is that as an executor, before you dive headfirst into your duties, it is very, very important to understand your roles, what your role as an executor will entail. The duties and obligation is very heavy. It's not for everybody. It's emotionally tolling, and it will take time to administer a estate properly until towards the end. And more often than not, it will take up to years. If the estate is big, it's going to take up to maybe more than 5, maybe up to 10 years. We don't know. So it's very, very important to get proper legal advice, because the duties of an executor is not one which should be taken lightly. And also, if you're looking into having a will drafted, appoint somebody whom you trust, whom your family can trust, and that person must be adequately skilled with the necessary knowledge, maybe basic finance knowledge, and also somebody who is very responsible in what you're doing. It's very important to do that, and also best to get all the parties involved in the as in what you're going to give out a clear picture of what is going on, to avoid miscommunication. In case if you passed away, you can't actually control what's going on. So it's very important to get the right executor. It's very hard, I know, but not everything is perfect. But in any event, get somebody whom you trust, or alternately, you can appoint a trust corporation to help you in that regard. So as an executor, if you in appointed under the will, like I said just now, heavy duties involved. And also, if the testator has passed away, as a beneficiary, it's not just sitting around and just waiting for the inheritance. Ultimately, you can, like what we have seen in the earlier slides, is that you can initiate actions in order to protect the interests of their state, such as the administration action, and also to remove the probate. So it's best to engage a legal professional to obtain advice as to how to proceed with the administration of the state. So in that regard, I will end this webinar. And we'll open the floor for questions. Ika, do we have any questions?
Nothing for now.
If there's no questions, I guess that the slides are quite clear. But if you have any questions, or you popped up only after this talk, you can send an email to me, and I'll try my best to answer your queries. So in that regard, thank you for your time, and I'll see you soon. Thank you.